Committee this Wednesday morning, February 4th, and we're going to be taking up H744. And it's, I'll give you a real quick background, and then I'll have Eric walk through a fairly short bill, and then Judge Treadwell, who's going to give us some deeper backgrounds and the reason why we have this. But so this came before the Joint Judicial Rules Committee this past fall, and Barbara chairs that committee, and Tom and Ian and I are on that as well. And there was, unlike most of the rules, it seems, that come before the committee, this one seemed to be quite controversial, and we had a lot of interest in this, particularly from the state's attorneys, from the BSEA, from law enforcement, and the underlying language that was prompted a change is actually language that the legislature put into this rule some number of years back. And rather than have that hearing with the judicial rules, we thought that this would be one that, since the legislature, I would say, erred slightly in the language that we had in the rule before, that we should be the ones to fix our mistake, and it would give us a chance to have a more open and a broader discussion and testimony. So that's how we've ended up so with this bill here, which is very close to the language that was in the rule that was proposed, and except for one change of a shall to may, which is always very important kind of change. But I'll let Eric kind of explain I think probably a slight explanation of what the judicial rules and how we look at rules would be in order, Eric, and why the legislature can also be the ones that can modify a rule. So I'll turn it over for you, and then walk through the language.
Okay. Thank you. And good morning, everybody. Eric Fitzpatrick with the Legislative Committee on Judicial Rules. Sorry, that is true, but not necessarily the only reason I'm here. With the Office of Judge Counsel, in my capacity as counsel for this committee, as well as counsel for the Legislative Committee on Judicial Rules, as the chair mentioned, you'll see that the proposed bill in front of you, rather than proposing to amend a statute, proposes to amend a court rule. It's Rule 3 of the Vermont Rules of Criminal Procedure. And in fact, that particular rule, you may even recall, this committee has spent quite a bit of time on over the last couple of years. It was in the context of assaults on healthcare workers. Remember, that was a lot of work was done, because this rule generally involves arrest without a warrant, and sets up the types of offenses for which an arrest may be made without a warrant, as well as outlines some procedures. And that's what this committee has dealt with many, many times over the years. And as the chair was saying, the legislature in general has authority under the Constitution to also amend court rules, as does the court itself has the authority to promulgate court rules. The legislature has a role in amending them within the context or within the confines of the separation of powers. So obviously, if there's a court rule that involves an inherently judicial function, then that would be something that the legislature wouldn't be able to amend. And obviously, there's also sometimes some disagreement on the gray area there. Well, is that a judicial function or is that a legislative function? As it happens, this particular rule, Rule 3, has been the subject of both judicial and legislative action many, many times over the years. So I think there's been, and even the comments to the rule indicate that there's a role for both branches to play in this particular role.
Okay. Just on this, it's timely today, I'll be reporting H5, which is on the hearsay exception rule. And so I think we've done this, right? Like, it's not new for us this year. We've modified rules. Yeah.
Yep, that's for sure. And it's in the Constitution that you have the authority to do that. As I say, balanced by the separation of powers, as long as you're within the judicial function, because separation of powers is in the Constitution as well. So you got to sort of thread that needle. And I think, as I say, everybody knows that in that gray area, there's sometimes some room for debate about whose role it is. But in this particular case, Rule 3 has been worked on by this committee and the legislature off and on for many. So that's a bit of the background. No, that works. Yep. Okay. So then the question is, all right, well, what's the proposal here in H 744? And as I mentioned, sort of the way Rule 3 works, the first part of it is this, it has to do with arrest without a warrant. And the first part of the rule is a list of when an arrest can be made without a warrant. And that, generally speaking, is for felonies. You know, either if the officer has probable cause to believe that a felony either was committed or is being committed in the presence of the officer. So felonies. Misdemeanors, if they're witnessed, generally. So if the officer has probable cause to believe that a misdemeanor is being committed in the presence of the officer. And then there's some, but not all, non-witness misdemeanors. So, and that was, you may recall, that's what this committee was working on with respect to like misdemeanor assault of a healthcare worker and preventing healthcare workers from performing their duties, that sort of thing. That's, you were adding to that part of the list. So that's the first part of the rule, the offenses that are covered. The second part is procedure, and that's what we're talking about today. That's what page 744 deals with, which is the procedure. And so if you think about it, if someone is arrested without a warrant, there's obviously a question of, well, what next? What then? And this particular proposal has to do with whether the person is released or not. So if there is an arrest without a warrant, so in other words, let's assume it fits into one of those categories we just described, and the existing language of the rule starts on line 16 of page 1. Excuse me, the law enforcement officer has to contact a judge for determination of temporary release pursuant to Rule 5 without unnecessary delay. So they arrested the person without a warrant. They got to contact a judge right away and discuss the issue of whether the person is going to be released or held. And the law enforcement officer has to provide the judge with an affidavit or a sworn statement, and you turn over to the next page, upon which the determination as to temporary release may be made. So again, sort of sets out the procedure there. The law enforcement officer provides an affidavit giving the circumstances of the arrest and the offense and those sorts of things. And so here's the proposed difference. Under the existing language, it just simply says the affidavit or sworn statement must indicate the crimes to be charged by the arresting officer. That's the way it is now. So you see, there's no reference to the state's attorney. It's just the law enforcement officer. The proposal is to involve the state's attorney in the process. And how specifically? Well, then you look at the language. The procedures and standards established by the presiding judge of each unit pursuant to Rule 5B. And I should say that under Rule 5B of the Rules of Criminal Procedure, said that the presiding judge of each unit shall establish procedures and standards by which persons arrested with or without warrant, other than during normal business hours, may be released pending appearance under this rule. So that's provided for in the rule. The presiding judge has to establish standards about that. And you think about the circumstances, right? Obviously, that's a question that comes up because it specifically says during normal business hours, right? So it's not during that time. And I think that people aren't structuring their arrest, so it only happens during, the offenders are rarely saying, I'm only going to commit this offense from 9 to 5, right? For purposes of the court's convenience. So they oftentimes have to deal with these situations outside of normal business hours, and that presiding judges have to set guidelines for their own units as to how those are going to be handled. So this provides some detail about how those can work. So as we just said, the procedures and standards have to be established by each presiding judge. And it specifically then says, starting on the line 4, those procedures and standards may, that's line 4, see may, and that's, as Chair Lalonde was saying, that's and I'm sure your witnesses will talk more about this, but that's a language difference between the proposed rule that the Committee on Judicial Rules looked at and the language that you're looking at right now. It was shall when the Rules Committee was looking at the proposed rule for the court. Here, the proposal is that it's may. So these procedures and standards established by the presiding judge may require that the affidavit or sworn statement include the charge or charges that the prosecuting attorney intends to file, and may require that the affidavit also include any conditions of release, including bail or an order to hold without bail, that the prosecuting attorney is requesting. So you see that what's happening there is that the prosecuting attorney is being involved more in this process than is the case under the current language, which only requires the arresting officer to indicate what crime they're going to charge the person with. And that's the proposed new way and now as to the details of how that would work in each unit, that's up to the presiding judge to establish, but certainly they have the option to require that the sworn statement that the law enforcement officer submits has to also include some information from the prosecuting attorney. I
This
think
is by
that's,
each different unit? By each different judge?
yep. Yep. And which is the case now, each presiding judge establishes their own procedures and standards by which persons arrested with or without warrant, other than during normal business hours, may be released pending appearance. So this kind of puts a little more detail on that, but they're already supposed to do at least generally.
Tom?
Well, no, I'm good. Thank you.
So only one thing I want to note here is the problem with the current language, which is on line 2, says that crimes to be charged by the arresting officer. The arresting officer does not charge crimes. There could be a very simple fix if we were to go with the additional language that the crimes to be recommended or the charges to be recommended by the arresting officer. But I wanted to have a little broader discussion of what was also in the rule that we took up in judicial rules. So any other questions for Eric before we go to Judge Treadwell? I don't see any. So welcome, Judge Treadwell. Nice to have you back in the committee. It's, I think, been a good while.
It has. Excuse me. Good morning, everyone. I'm John Treadwell. I am a judge presently assigned to the Windham Civil Division. I know a number of you because I used to appear in that committee very regularly in my former role, and also because at least one of you used to appear in front of me as an attorney in Windham County. But I thought it might make sense for me to give you a little background about me and my work in this area before getting into the more substantive issues about the rule. And again, thank you for letting me appear remotely. I have a juvenile calendar this afternoon, so it will be slightly problematic to get from Windham to Montpelier and back to Windham. So I am presently assigned to the Windham Civil Division for since I was appointed. I did spend 7 years assigned to the Criminal Division, 5 of them in Windham County, 2 of them in Windsor County. Before I was a judge, I was an assistant attorney general in the Criminal Division of the Vermont Attorney General's Office for about 17 years, where I regularly appeared in the legislature on criminal justice matters, primarily in this committee and also in the Senate Judiciary Committee. And before that, I was a deputy state's attorney in the Chittenden State's Attorney's Office for 3 years. I've represented the state in the legislature, in the Vermont Supreme Court, in state court on felony and misdemeanor prosecutions. I've also represented the state in post-conviction relief work in both state and federal court as part of my career before I was appointed as a judge. I am presently chair of the Advisory Committee on the Rules of Criminal Procedure. I was appointed in 2021 to that position when succeeding Judge Zone when he was appointed as Chief Superior Judge. I'm also a member of the Criminal Division Oversight Committee and one of the judges on the Sentencing Commission. As part of my work in the AG's office, I was heavily involved, I think it would be fair to say, in the very significant legislative amendment to Rule 3 that happened in 2001. Basically, we rewrote and restructured the entire rule. Since then, both the legislature and the Criminal Rules Committee, the court, have been involved in amending the rule, various portions of Rule 3, but also the rules of criminal procedure generally. The purpose of 3K, I think, as Eric has outlined, is really fairly narrow, but also critically important. It deals with the proper mechanisms for setting bail and conditions of release for persons who are detained after hours without warrant pending their initial appearance or arraignment in the court. This detention can be fairly brief. If a person is arrested in the early morning hours on a weekday, they can be in court that day. The detention can also be fairly lengthy. If, for example, a person is arrested after hours, without warrant after hours on the Wednesday before Thanksgiving, they won't be seen in court until the following Monday. So this rule does, in fact, affect significant liberty interests of people who are presumptively innocent. The purpose of the rule is to ensure that the judicial officer who is making the decision regarding bail and conditions has the maximum available possible information to make an appropriate decision regarding temporary release on bail or conditions, to protect victims, to protect the community, to ensure that the defendant will actually appear in court on the next business day, and also to protect the liberty interests of presumptively innocent persons. So as Chair Lalonde and Eric have both mentioned, there was a proposal that the Criminal Rules Committee had been working on to amend the rule to address this issue of the language that exists presently, which is problematic about charges to be filed by a law enforcement officer, since that is not actually a thing. The rule in its current version has been changed fairly regularly in the last 7 years or so. The amendment to 3K to add the requirement that an affidavit be provided to the judicial officer was added in effective July 1, 2018. That's been in effect for more than 7 years at this point. There was subsequently an emergency amendment also by the court, also in 2018, to address whether or not the prosecutor was actually required to file an information, a charging document, in conjunction with that affidavit. That language was clarified and stricken. Then in 2019, in July of 2019, the legislature made effective the current language, which struck any reference to the state's involvement and left it that the affidavit has to be provided, and there is this reference to a charge by law enforcement. Subsequently, Criminal Rules took a look at the rule to address the issue of whether there should be an update here. Criminal Rules spent a fair amount of time discussing that. And ultimately, there were 3 proposals put before the committee for potential changes. The first proposal is almost exactly identical to the language you have here. The second proposal was that the affidavit must include the charge or charges to be filed by the prosecutor and may include any bail or conditions of release. And the final proposal was must for both. So it must include the charges and must include a recommendation as to bail or conditions of release. The committee's vote, which was unanimous, was to have must for the first option for the charges to be filed and may with respect to conditions of release. That was forwarded to the court. The court promulgated, well, did not promulgate it. It was issued for, it was published for comment. And ultimately, as part of that process, after the comment period is run, it goes before the Legislative Committee on Judicial Rules. No comments were received by the court or by the committee during the comment period. The matter then went before Judicial Rules, where there was some concern, well, comments were raised, concerns were apparently raised with committee members that had not been brought to the Criminal Rules Committee. And ultimately, there was some discussion about the possibility of the legislature acting rather than the criminal rules process continuing. I can tell you that because it was a proposed rule, it has been returned to Criminal Rules, because that would be the next step after a proposed rule is initially reviewed by Judicial Rules. And it is 3K is on the agenda for the next Criminal Rules Committee, which is this coming Friday. I did, as a courtesy, in light of the comments that the legislature had received, offer both the Department of State's attorneys, the Defender General's Office and the representative of the Vermont Bar Association the opportunity to submit additional comments to the Criminal Rules Committee for consideration at the next meeting. I can tell you that there were some comments received from the deputy state's attorneys. They are identical to the comments that were submitted to the Legislative Committee on Judicial Rules. And the court also received, the committee received 4 comments from 4 state's attorneys. There were no other comments. And again, we will be discussing the rule again at the next meeting. Obviously, I will be reporting on the fact that the legislature has taken up a proposed amendment to the rule as well, and that I will have testified on it. So I think it's worth understanding if at least in a sort of fairly simple level how the process works in terms of calls for bail and conditions of release. As Eric made clear, Rule 5B makes it clear that that's a sort of county by county process. The judiciary allows only judges to set bail or hold a person without bail pending initial appearance. So if there is an after-hours call and there is going to be a request that bail be imposed or that a person be held without bail, that has to go to a judge. If the request is, however, just for conditions of release on a misdemeanor or felony, if they are a misdemeanor, the call can also be made to one of the court operations managers in the various counties. And if it's for a felony, it can be made, the calls can be made to clerks. With respect to the coverage in the particular counties, that varies from county to county. In some counties, the judges rotate on call and take turns to take calls from law enforcement officers after hours on criminal cases. In other counties, the criminal judge takes the criminal calls, the family judge takes the family calls, and the civil judge generally doesn't get called very often. In Windham and Windsor County, the practice was for the criminal judge to take the calls. So from September 2018 to September 2025, I was the on-call criminal judge for 7 years. I was the first person called if there was a request to hold someone without bail or for bail. I don't think it can be overstated the importance of having accurate and as complete information as possible as part of this process. The affidavit will set forth basic facts establishing that the law enforcement officer has probable cause to believe that crime has been committed. But those facts alone aren't going to be enough generally for the court to decide what are appropriate conditions of release or bail. Ordinarily, we would want a substantially additional amount of information. Are there allegations regarding prior conduct? What is the record of convictions of the defendant? Have there been prior failures to appear or examples of flight to avoid prosecution? During the incident, is there any information that the defendant was using drugs or alcohol? Are there threats of violence that have been made? What is the defendant's family and community ties? What is the defendant's residence at the time of arrest? If the court is going to issue conditions precluding a defendant from returning to their residence, where would they be residing pending initial appearance? What is the length of the defendant's ties to the community? These are all facts that judges generally are interested in knowing about in determining appropriate bail and conditions of release. Importantly, the charging decision, and understanding that it would only be a preliminary review, but the charging decision that the state will make is critically important because that frames the options that the judge or the judge is going to be able to apply or impose. For example, if a defendant is potentially going to be charged with a felony crime of violence, then they can be held without bail pending arraignment. If the defendant is going to be charged with a crime that might be sealable, the court would generally be capped at setting bail in the amount of $200. When we receive an affidavit from a law enforcement officer, it describes conduct. And often that conduct can be charged under various different offenses. I mean, I can conceive of a set of facts that could cover charges from first-degree aggravated domestic assault to disorderly conduct. The charging the decision the state may make would have an enormous effect on what conditions or bail that the court could impose. So from the court's perspective, it is vital to have that information. Additionally, charging decisions belong solely to the prosecutor. I can read an affidavit and have some idea of what the state might charge, but that is not my job. That is a pure executive branch decision. There are also statutes that expressly, there is one statute that expressly involves the state in this decision. A number of years ago, excuse me, the legislature enacted 13 VSA section 1048. And that provides at subsection B, a person cited for domestic assault shall be arraigned on the next business day after the citation is issued, except for good cause shown. Unless the person is held without bail, the state's attorney shall request conditions of release for a person cited or lodged for domestic assault. So that's one particular area where the state's attorney is expressly drawn into that decision. I can tell you that many judges, as part of the practices in their procedures in their counties, require that there be a call to the state by the law enforcement officer. There have been some discussion with the prosecutor before the judge is called and before the judge makes a decision as to bail and conditions of release. And the discussion in criminal rules was that that is best practices. I think what the language does here in H7044 is it codifies, in some sense, the practices that are already authorized under Rule 5B, and just clarifies a point that where the court or the judicial officer already has authority. I know I've been talking for a while. Are there any questions?
Scott.
Can you just remind us who is on the committee? That is,
On criminal rules?
yes.
Certainly. There are 3 judges on the criminal rules committee. Those would be myself, Judge Morrissey, and Judge Gray. All of us were former prosecutors in our pre-judicial officer careers. Then there is a representative of the Department of State's Attorneys and Sheriffs, that is Rutland County State's Attorney Ian Sullivan. The chief of the criminal division of the Attorney General's office is there as the designee of the Attorney General. There is a designee of the Defender General, that is Appellate Defender Rebecca Turner. There is the chair of the criminal law section of the Vermont Bar Association, and there are 3 criminal defense attorneys, a victim's advocate, and a court clerk. So it encompasses basically all the stakeholders in the court system.
And you've sort of alluded to issues, but have issues come up a great deal sort of statewide since the change that was made? And I'm trying to remember which of the changes, but it sounds like in 2018 or 2021, which makes it that the state attorney doesn't necessarily need to be sharing the charges that they intend to file.
So I think the practices vary from county to county, and there are counties, a number of counties that I'm aware of, where the state's attorney is involved, either by the state's attorney themselves establishing a policy that they should be involved, or because the assigned judge has required them to be involved. There are counties where the state's attorney is involved when certain charges are filed and not involved when other charges are filed. Windham County is one of those counties. That can result in some somewhat unusual requests. When I was on call at one point, I was asked, an individual was arrested for violating conditions of release. That is not one of the offenses for which the state's attorney's office are called in Windham County. And the law enforcement officer asked me to hold the defendant without bail pending arraignment. And a request that is not authorized by statute, law, or constitution. Obviously, I didn't do it. I'm not sure if there are problems from county to county. I think that there is the concern that is being addressed here is ensuring that judges and court clerks and comms, when they are involved, have the information and have access to the information that they need to make an appropriate and proper decision regarding detention, which also encompasses potentially protecting the public.
Morning, Judge. I just want to make sure I'm 100% clear on this. I don't have Rule 3 open in front of me. This is K. This doesn't have anything to do with citable offenses, correct? This is when someone is going to be held, correct? And then, and only when someone is to be held.
No.
Or requested to be held.
It also applies. It applies whenever a person is arrested without warrant and is not being released on a citation down the road. So it's in every case where there is an arrest without warrant and either request to hold without bail, to hold on bail, or to impose conditions of release. It's those three sets of circumstances. But
it won't. So if a citation is not issued, it's not applicable, obviously. Okay.
Or if its citation is issued and there is going to be no request for conditions of release. So, you know, your regular citation for retail theft, I'm citing someone 6 weeks out.
Right.
3K is not implicated. It's only in circumstances where there is going to be a court order of some kind that implicates, frankly, the liberty of a defendant by holding them or subjecting them to court-ordered conditions which are enforceable as criminal offenses.
So if someone is arrested for, say, a felony by a law enforcement officer and Rule 3 says that they can be lodged, I'm still going to have to go through the process of speaking to a state's attorney when I may know that, yeah, well, it was a burglary. I don't really have to consult with anybody to understand that it was a burglary. And so I still have to talk to a state's attorney in the middle of the night and attempt to get conditions of release as well as bail all arranged with something that they're looking to have instituted on this subject when they go to court, and when in fact maybe when they go to court there's a whole bunch of different information and they may set completely different conditions. I'm just concerned about waking people up in the middle of the night. I think Rule 3 is pretty effective at knowing when to put somebody in jail or when to release them on a citation. And I thought that's what it did. And I think it did it pretty effectively.
I mean, it is a process that provides an effective mechanism for ensuring that there is appropriate review of bail or conditions pending initial appearance. The rule has required for more than 7 years now that before there is any call to a judicial officer, that the affidavit must be completed, and the affidavit has to be filed, has to be provided to the judge. Some judges are comfortable with the officer reading the affidavit to them. Some judges are comfortable with the officer summarizing the affidavit. Other judges want to actually see the affidavit before setting bail and conditions after hours. That's one of those county by county decisions. The issue here is fundamentally whether there is additional information that the judge should be considering in determining the amount of bail, whether bail is appropriate, even what types of conditions are necessary. All of these, it's ensuring that the court has all of that information pending the appearance the next day. I understand, every judge understands that when the case comes in the following day, there may be additional information. There may be reconsideration of the charges that are going to be filed. What happens overnight does not in any way bind what the state asks for the following day and what the court orders the following day. But there can be significant issues. If a person is arrested and it could be a first-degree aggravated domestic assault, there may be a request overnight to hold a person without bail pending the initial appearance. But if the state only charges a misdemeanor the next day, the defendant arguably was deprived of the opportunity for release that they were entitled to under both statute and constitution.
Wasn't somebody contacted and read the affidavit that should understand the difference between a misdemeanor and a felony and set the bail accordingly?
Absolutely. The affidavit may set forth facts that support it being charged as a felony or a misdemeanor. The charging decision, however, belongs to the state's attorney. And I certainly see many affidavits and many charging decisions where the charges that are actually filed are different than recommended by the law enforcement officer, and perhaps different than I would have charged back when I was a prosecutor. But I understand that that's not my role as the judge to determine the appropriate charges to be filed.
Thank you. I'm asking these questions because, well, being a former, well, still a law enforcement officer for 40 years, I've called many judges in the middle of the night, and if they see a problem with my affidavit, they point it out and I fix it. Or if it's not charged properly, very, very often, I will call and consult with a prosecutor if I have a question. And generally, you will talk to a more superior officer if you have a question when you're starting or learning, and bump something by them. And if it becomes at all like questionable, you do reach out. I just think making the requirement in the middle of the night might be a bit extraneous.
Yeah. So the language that the committee has in front of it would give, it expressly gives the judge in the county the authority to require the state to be involved in the process. It doesn't require that the state be involved in that process. That is left up to the individual judge assigned to the presiding judge in that county to determine what they believe is the appropriate policy that should apply in their county. And again, I think that is the existing rule authorizes that. This just clarifies the authority under existing Rule 5B.
The only other thing that makes me a little nervous about it is I've been known to work in 3 different counties on any given night. And so it's hard to keep track of. That's all.
I certainly appreciate that this implicates after hours work, and that there are complexities associated with it.
Ian.
Hey, Judge. Thank you very much for being here. So full disclosure, yeah, I'm a deputy state's attorney. I'm actually currently on call. I have my on-call phone on me right now. I think it's important for me to mention that before I ask a question. So you've seen all of the responses that we've gotten from SAs and DSAs. You've seen the sort of counter argument around attorney work product.
Yes.
What's your response? And I can elaborate. So just for
Yes.
when is the actual charging decision made?
An actual charging decision is finally made when the state files an information the following day. What we are asking for here is information, understanding that it is preliminary as to what the state might expect to charge, because that implicates the decisions that the court can make with respect to bail and conditions of release. I'm not sure how this implicates work product. The affidavit does not require that the affidavit recount any discussion between the law enforcement officer and the prosecutor as to what the prosecutor's charging thought processes are underlying the charges. All it would need to say is the state may charge domestic assault, aggravated domestic assault. I don't see how that implicates work product.
Even if then the next day that charge isn't there at all.
Yes.
So now parties looking at the affidavit would say, oh, well, like, what was that on-call attorney looking at? That, you know.
Right, but so I think 2 points. I don't know how that would be relevant to any discussions going forward, either in court or in the case. The issue the following day will be the actual charge filed by the state, not what the state may have thought it would charge based upon preliminary information. And of course, the information is going to be preliminary in the middle of the night. I understand that. I don't see how that in any way binds the state or discloses the internal thought processes of prosecutors.
Okay,
I mean,
and then
can I make one more
Please.
point? I mean, that it is the practice, I think, in every county that I'm aware of, and someone can correct me if I'm wrong, that after-hours search warrants are reviewed by the prosecutor before being acted upon by a judge. That is another area. The rule does not expressly allow for that, but every judge that I'm aware of, before issuing a search warrant in the middle of the night, requires that the law enforcement officer have consulted with the prosecutor before seeking a warrant. I don't think that implicates work product, and whether that somehow discloses that the state's attorney believes that there is probable cause to believe a crime has been committed and evidence of the commission of a crime will be found in that particular location.
So if the judges can already do this,
Yes.
I mean, why do we need this? And is the system broken? That's not what I'm hearing. It sounds like it's working, and this is a good philosophical discussion, but is the system actually working sufficiently?
So, I mean, as we've mentioned, the existing language in the rule needs to be changed.
Right. Agree with that.
Yeah. As part of the process, the thought of the committee, the Criminal Rules Committee, was that clarifying the authority of judicial officers consistent with Rule 5B was appropriate under the circumstances. And that's what we were seeking to do. And I think that's exactly what H744 does as well.
Although probably the use of shall or must instead of may actually didn't just clarify that.
Yes, I suppose so. I think a judicial officer in a county could require that the affidavit include this information. So even without the language of a rule, the judge could say that if I am going to get after-hours calls, the affidavit must include this information.
So this wouldn't necessarily change per practice, the bill with the may instead of a must. So, and is there, and we'll hear more testimony, but I think, based on what you've already seen, is there a compromise somewhere in this? I mean, as far as there being only certain charges, or is that really something that should be left to the discretion of the individual judges?
Well, I think judges and judicial officers who are making these decisions during the night should have the authority to determine what information they believe they need to make a proper decision to protect the public, to protect the victim, to ensure that the defendant appears the following day, and to protect the defendant's liberty interest. It is important that we be able, if we need to ask for this information. And that's what we're asking. That's what this language does. I'm not sure what the compromise is, that somehow there are cases when we're not allowed to ask the state's attorney to weigh in. That would be concerning, to say the least.
Yeah, okay, fair enough. So the way it works, I mean, can it be under current system more of an ad hoc situation that, depending on what the affidavit says, if the judge needs more information, that's when the law enforcement needs to bring in the state's attorney?
It could, but we're trying to make this process as efficient as possible, involving as few phone calls as possible at 2:00 in the morning. The reality is, again, that judges, and I know, for example, Judge Zone is one of these judges when he was, before he was Chief Superior Judge, require the state's involvement. There are other judges that do that. As long as that is still a possibility, I don't know that a rule that doesn't allow for that is appropriate.
Right, okay, understood.
Yeah.
Yeah, Ken.
So it's taken me a little bit of time to catch up with all this verbiage with the lawyer stuff. But are we tied up on this one word on line 7, to, and then require? And what the chair was just implying, I think, was may require or must require. Is that really where this wording is coming from?
So the may must question, the question of whether the affidavit must contain certain information, it is not in this draft. This is only may. This is only giving the court the opportunity, the court the right to, the clear right to ensure that that information is involved. It's left up to the individual judge. If the language was must, the judges in the county wouldn't have a choice as to whether this information would be included or not.
And that must, now you're implying that, I understand you must before in the other areas. Now you're going back to the must on where I'm asking about line 7.
So when you're talking about line 7, Representative, you're referring to the statement of purpose of the bill, is that correct?
Yeah, to. Just
Yeah.
that first word, to.
Which page? First page or second?
First page.
This bill proposes to permit courts to require certain information. So I think that the to require has to be read with the permit in the prior language, that it's clarifying that the judge has the opportunity to require it. They don't have to.
So you're on line 6, I'm on line 7.
Yes.
I'm on line 7 where it says to require. That's where I'm hung up on, is that to there.
Okay.
Should that be a different word that
So
may or must?
So that's only the statement of purpose for the bill. The actual language in the bill, the operative language is on page 2 between lines 2 and 7, which describes how it actually will work. And that's where the may language is in there. The statement of purpose is just an overarching description of how it is intended to work.
Going back, not to keep beating this, but going back to 7, when you have that word to in there, it's like when I first came in here, this may and shall, those 2 words there just kind of like were very, very important, different words, right? In interpretations of it, the whole 9 yards, right? So I'm just wondering if that affects what we're trying to do, what the bill proposes to do on page 2. If that makes sense.
Yeah, it does make sense. I don't believe it actually affects the language on page 2. The distinction you're drawing is, I think, an important distinction, the distinction between may, which is permissive, and shall or must, which is mandatory. And the description here, including line 7 on page 1, describes a permissive, a may-based regime, which appears on page 2 between lines 2 and 7.
Okay, thank you, thank you.
Thank you, Representative.
So we probably have a decision here as well, and after we hear from other witnesses of whether we take action on this or wait and see what happens on Friday. But if we just wait till Friday and we'll just be back to the same place, possibly when we look at this rule again sometime this spring. So maybe we can come to some conclusion here, but anything else from you at this point, Judge? And are you able to stay on at all in case other questions come up?
I can probably stay on at least through late morning.
Okay, yeah. Well, hopefully we'll be done by then.
Okay.
Okay. All right. So
thank you very much, everyone. It's nice to have the opportunity to appear before this committee again.
yeah, it's good to see you.
Thank you, Your Honor.
Take care.
Thank you.
All right, so we'll go to Kim McManus, and then after Kim, we'll take a short break.
Sorry. Eric.
Right out with the question, or did you have a prepared statement first?
Is that
By the way, my first sentence was amazing, but go ahead.
Oh, go ahead. Go ahead. No. So, well, it's like, it sounds to me like the language that we have here is just clarifying what's happening right now. And with the may, that judges can require state's attorney's involvement or DSA involvement. Is that?
McManus, for the record.
I apologize. You can have that question in the back of your mind when you testify.
And with me today, I have Deputy State's Attorney Eliza Novick-Smith from Chittenden County State's Attorney's Office, who I'm really going to give the bulk of our time to because she is regularly on call, like Representative Goodwin. I had very limited on-call experience, thankfully, when I was prosecutor. But I just want to talk about our department-wide concerns with this. And just right out of the gate, to your question, when this rule was initially proposed with the shall language, that every warrantless arrest would need to have a prosecutor involved off hours, we absolutely were wildly concerned with the impact on our office of the on-call demands. The change to may doesn't necessarily take that concern away. If anything, it just makes it a little bit more chaotic, to Representative Oliver's point of each county having a different set of rules. And to be perfectly frank, I think if this language is here, why wouldn't a judge want to require this, if they're able to have the prosecutor do that work during the off hours, it most certainly makes the judge's job easier. And we appreciate that the judge wants all the information as much information as they would want to make these important decisions. We believe that law enforcement has the vast majority of that information that's being requested. And again, as Representative Oliver stated, if they don't, they are checking in with a DSA or SA who's on call. We do have somebody on call in each county available for these questions. We're just concerned that this is a slippery slope to absolutely every warrantless arrest needing to run through a prosecutor, and that our prosecutors, and again, if we're going to take a break, I do want to make sure all the time is dedicated to DSA Novick Smith to speak to this. You've heard repeatedly the workload that our prosecutors have, on average 400 cases. In our larger counties, we have more DSAs available for on-call, but we have more on-call that occur. In our smaller counties, when we have one SA and one DSA, half the office is on call every night. And they need to address these calls during the night and then have their full caseload during the day. These calls can sometimes be a 15-minute phone call. Sometimes this call is an hour. And our concern is that with this change, we would be increasing the load dramatically to the point where it would affect our ability to retain attorneys and hire attorneys, which we know is an issue statewide for I elevated him, Defender General Valerius to this. Didn't mean to make him governor. This summer at Joint Justice, of the hiring issues that the defense bar is having, we are having the same problems. And we have to explain that when you're on call, you may be, and again, it's not every night. We know that. DPS was able to send me a few numbers that in 2024, there were 3,468 warrantless arrests in Vermont in the year. That averages out to about 9.5 a day. They usually
Just state police or all one?
That's all Vermont. These generally tend to come in clumps and groups, and we're just incredibly concerned. We don't think it's necessary. We don't understand the problem that it's trying to solve. If there are particular instances, like an officer calling to have bail set on a VCR, that's an education issue that can be dealt with in the county with that law enforcement agency, with the SA. It does not require a rule change as proposed. Again, I would like to have, I don't know if you need a break before we.
I think we will have a break because I think that Eliza's going to be the last witness this morning, so we have plenty of time. But we'll probably need a break first. But let me just ask though, if this language was gone and somebody like Judge Zone back in the day, it sounds like he required this information. And what would a state's attorney do if they disagree with providing? I mean, they provide that information. I guess it's.
Again, I think we're concerned, and I would again love to sort of move it to my colleague. We're concerned with it then slipping into just a reflex that every single warrantless arrest would need to go through this process. And the workload on law enforcement and on us having to do all of that communication off hours versus now it's very particular instances where they need to pull in the DSA or the SA, not for every single bail decision that can pretty easily be made with the information that law enforcement has and that the judge can make. We understand that there are particular instances, and like you said, it's done right now. This rule change doesn't affect that. We think it's functioning as is, and that the problems that do exist again can be managed through education and training. Not going to what we think again will just open it up to then becoming just a requirement over time that every time there's a warrantless arrest off hours, a prosecutor has to be called.
So, but as far as you don't see an alternative or a compromise somewhere in here is what I'm,
Our preference as a department is to strike the new language. We do not think it's needed. We appreciate that in the last sentence on, well, what we would recommend would be the last sentence on line 2 is to change that, the charge by the arresting officer to language such as recommended by the officer to be in line, that the officer is not charging, he's recommending, he or she is recommending the charges. That's all we think that's needed at this time as a department.
okay, great. Thank you. So we'll take a break.